Good evening, ladies and gentlemen. My name is Randy Sue Pollack, and I'm the immediate past president of the Federal Bar Association for the Northern District of California. I'm pleased to welcome you to this evening's special program, paying tribute to Judge William Alsup, who has served on our bench for over 26 years. Before the special conversation between Judge Donato and Judge Alsup, we will be hearing from Professor Edward Lee. Professor Lee is on the faculty at Santa Clara University, where he teaches copyright law, design law, international intellectual property law, and torts. He founded the website ChatGPT is Eating the World, where he analyzes the impact of AI on copyright litigation. At the close of the conversation between Judge Donato and Judge Alsup tonight, I'm going to return and talk to you a little bit about the role that Judge Alsup has had with the Federal Bar Association. So I'll now turn the program over to Professor Lee.
Thank you, Randy Sue. I have the great privilege of introducing our special program tonight to celebrate our guest of honor, Judge William Alsup. Now, it's a daunting task to introduce a judge who really needs no introduction, especially in this vast community of judges, lawyers, and Bar Association members here in San Francisco and the Bay Area. Judge Alsup is, in a word, legendary. But please indulge me for a few minutes as I try to convey at least some of the accomplishments that have made Judge Alsup one of the most influential and important jurists in this country for the past 26 years. As some of you know, I made an introduction of Judge Alsup for a conference that I hosted at Santa Clara School of Law. And the theme of the conference was how it started, how it's going. We were celebrating the 50th anniversary of the Copyright Act and the 80th anniversary of the Lanham Act, and fittingly, it is the 26th anniversary of Judge William Alsup's tenure on the bench. So consistent with that conference's theme, let's start with how it started. For Judge Alsup, it started in Jackson, Mississippi. Judge Alsup grew up during segregation in the Jim Crow era. But as he movingly described in his memoir, Won Over, Judge Alsup joined the civil rights movement as a college student, including participating in protests and helping to organize a student on-campus event in 1967, hosting the first black speaker to speak at Mississippi State University or any other white college in Mississippi. That speaker was Aaron Henry, a pharmacist, civil rights leader, and the president of the state's NAACP chapter. With his friends in the same Young Democrats student group, Judge Alsup hosted Mr. Henry's talk on campus. But that was no small feat back then, during the height of segregation. The university had a policy banning any speaker it deemed to be too controversial or dangerous. This policy was basically a way to keep civil rights advocates away. The university, not surprisingly, denied the student request to invite Mr. Henry to speak on campus, but Judge Alsup and his friends persisted. They wrote a protest letter to the university president, which was published in the school newspaper, and received the further support from a letter written by the faculty. But the letters prompted no change by the university. So what did Judge Alsup and his college friends do? Well, I think you all can guess in this room. Yes, they decided to file a lawsuit against the university. They even found a lawyer willing to represent them pro bono, along with receiving advice from the ACLU about their First Amendment rights. Judge Alsup wrote a letter to the university president, carefully explaining their reasons for filing this lawsuit. Judge Alsup's letter and the threat of a lawsuit are what convinced the Board of Trustees of the university to reverse their decision. It was a very persuasive letter. Even before a lawsuit was filed, the university allowed Mr. Henry to speak on campus about the passage of the Voting Rights Act before a crowd of 800 students, a historic event. Now, the lesson of this and other peaceful protests during the civil rights movement are still relevant today, when many people, including this past weekend, are engaged in national protest of our government's policies. What Judge Alsup wrote back in 1967, as a college student, still resounds today. They were protesting because they sought, in Judge Alsup's words, to further the task of living with and not against our fellow citizens. Judge Alsup's involvement in the civil rights movement during college was formative. It was one of the experiences that led Judge Alsup to switch his studies and career goal from engineering to the law. Now, in the interest of time, let's turn to how it's going in Judge Alsup's legal career. Judge Alsup received his law degree from Harvard Law School and a Master of Public Policy from the Kennedy School of Government. Clerk for Justice William Douglas on the Supreme Court, and in between stints working as a highly accomplished trial attorney at Morrison and Forster right here in San Francisco. He was an assistant to the U.S. Solicitor General, arguing cases before the Supreme Court. In 1999, Judge Alsup was appointed and confirmed as a federal district court judge here in the Northern District of California, and we are all better for it. During the past 26 years, Judge Alsup has written thousands of opinions and orders in cases of great complexity and significance. His decisions have in turn been cited by other courts thousands of times. That's every law professor's dream, that number of citations. Judge Alsup has presided over and decided some of the most important cases for this country. For those of us in the field of IP, including myself, we are most familiar with his decisions related to law and technology and intellectual property law. Bartz versus Anthropic, Google versus Oracle, Waymo versus Uber, Sonos versus Google, to name just a few of the many technology cases that Judge Alsup has presided over. But Judge Alsup's impact is far and wide in many areas of law beyond intellectual property. He has issued important opinions in lawsuits related to a class action challenge to the government's recent termination of federal employees, the government's termination of the Deferred Action for Childhood Arrivals or DACA program, PG&E's criminal probation for its role in the 2010 wildfires, a class action challenge to the government's process for student loan forgiveness, and even the contempt proceedings against the former trainer of Barry Bonds in the Balco scandal. I should add, he presided over a class action antitrust lawsuit involving NVIDIA in 2007, before NVIDIA became the AI chip juggernaut that it is today. These cases obviously had great significance, not just for the parties, but for this country. Now, I think everyone who has read a Judge Alsup's opinion will agree. They are clear, crystal clear. In a recent profile in Bloomberg Law, Judge Alsup, who is an accomplished photographer, as many of us know, has likened the process of writing a judicial opinion to taking a photograph with careful framing, sharp focus, and the ability to find and isolate a strong, clear subject. Judge Alsup's opinions are also literary, often containing a memorable line or arresting phrase, words that pack a punch. Of course, his opinions are exceedingly careful and meticulous on the facts and the law, with an uncompromising attention to detail, much like an engineer would devote. And they are incredibly insightful and typically correct as a matter of law upon review by our appellate courts. Consider an example from copyright law, which is my specialty. Those who study and practice copyright law all know that Judge Alsup's ruling on fair use in Google versus Oracle was ultimately vindicated by the United States Supreme Court. But what few people may realize is that Judge Alsup's same ruling in Oracle was vindicated not once, but twice by the Supreme Court in the Supreme Court's later ruling in the Andy Warhol Foundation versus Goldsmith case. Because in 2016, Judge Alsup ruled in Oracle, and I'm quoting his analysis, one use by the defendant might be a fair use, but another use might not, and the 4 statutory factors of fair use are to be applied on a quote-unquote use-by-use basis. And the judge then quoted Section 107 and its text. Judge Alsup's opinion is the first federal decision interpreting the 1976 Copyright Act that clearly stated that fair use analysis must be conducted on a quote-unquote use-by-use basis. 7 years later, in the Warhol decision, the Supreme Court adopted that same use-by-use approach, saying it requires fair use requires an analysis of the specific use of a copyrighted work, and the same copying may be fair when used for one purpose by the defendant, but not another. Now, a number of legal scholars have recently written about Warhol and the use-by-use approach, including myself. But who knew we could have written our articles back in 2016 after Judge Alsup's decision in Oracle. Now, this one example is emblematic of Judge Alsup's decisions, drawing legal insights that escape the attention of most others, and doing so in a way that is clear and laser-focused. As Judge Alsup put it in an interview, one sentence can be worth pages. Now, the parties and lawyers who appear before him, Judge Alsup is known as a tough, and I would emphasize tough, but fair judge, who is committed to equal treatment, fairness, and decency. Indeed, these are the principles that have guided Judge Alsup's participation in the civil rights movement as a college student, and they are the principles that thread all of Judge Alsup's decisions, even to his last decisions handed down just a couple months ago. In one of them, Judge Alsup ordered changes to a class settlement website because it did not afford, quote-unquote, equal dignity to the choice of those class members who elected to opt out of the settlement. With his characteristic attention to detail, Judge Alsup basically went line by line and redesigned parts of that website to ensure it gave equal dignity to all class members. Incredible. Respecting the equal dignity of all members is an enduring lesson that we all can learn from Judge Alsup. To sum up his tenure as a federal judge, I will take the liberty of borrowing the judge's own words from a recent decision many of us know well. While the judge was referring to the technology of AI, please allow me this poetic license when I say, Judge Alsup is one of the most transformative judges many of us will see in our lifetimes. Now, enough speaking by me. I will now turn it over to Judge Donato for the fireside chat. Thank you so much.
Thank you, Professor Lee. I see many FOBs out here tonight. Tonight we're all friends of Bill, or friends of our Bill. And if you ever miss him, look at that spectacular portrait with the Rangers hat at the end. So for the next 45 minutes, we're going to hear from Judge Alsup about some of the experiences that made him, in my view, and the view of many, many others, a once-in-a-generation judge that we have been privileged to have in our district for the last 26 years. If we have time at the end, we may be able to fit some questions in, so think of them. Non-incendiary questions and burn the courthouse down time questions consistent with our discussion if we can get to it. Bill, I want to start with 1971, when your legal career began with a bang. You went right from Harvard to the chambers of Justice William O. Douglas. At that point, Justice Douglas was nearing the end of his tenure on the Supreme Court as the longest-sitting Supreme Court justice in history, and he was, by any measure, a larger-than-life figure, both on and off the bench. So we're going to get into some of the details of the work that Bill did. Let me just start by asking, what was it like to start your legal career by clerking for a legend?
I'm going to answer that. I want to thank Professor Lee for not mentioning all those rehearsals. And I want to say to my wife who's here tonight, wife 58 years. No. Yes, 58. I'm about to get in trouble. She's been by my side through all of this, and it's been a blessing to me. Thank you. Justice Douglas has a reputation, undeserved, I think, for being a tough guy to work for. And there's some terrible things out there in the press that have been repeated even by the New York Times. He was an old school guy. He expected you to do good work, but he had a compassionate side. So I want to tell one story. He never told us when we had to be there and when not. We worked every day, Christmas, New Year's. We worked every day. We did that ourselves because we had a lot of work to do. He never said be here at a certain time, but we were always there, almost always before he arrived. And but one day, the three of us, toward April, we wanted to take one day off to be able to go on an annual hike that he did with a group of people that saved the C&O Canal from being paved over. That's a whole different story that I'll just assume you know it, but he in 1954 led a march from Cumberland all the way to Georgetown, 10 days with the editors of the Washington Post, drinking a lot of scotch at night and camping out. Big fires, he had botanists, zoologists, and they saved the C&O Canal from being paved over. So they had an annual memorial walk. That year was from Antietam, 13 miles toward Washington. And we wanted to go. The three Longhorns wanted to go. So we wrote a note. We didn't just go in and say, hey, no. We wrote him a note. Could we please take that day off and go on the hike? We didn't hear a word. A whole week went by. He didn't just come out and say, oh yeah, sure, yeah. No. So we thought that was really his way of telling us, you need to be working here. It was an important term, a blockbuster term. We got 186 orders to get out. So in the second week, though, one day he came out, and he had his overcoat. He was on his way home, and my little table was right by his desk, by his door. And he came out, and he just began talking like we had been listening to him from inside his chambers. He began talking. He put this big piece of paper out on my desk, and we all gathered around. And the first thing he said was, here's where you should camp the night before. And he pointed to an X, and it was in a municipal park in Antietam. So we said, we're thinking, he's going to let us go. He's going to let us go. And so then he said, now, and I've already cleared it with the town council. They're going to let you camp out there, bring your camping sleeping bags. So he had the X, and then he had another, I guess it was a Y. Meet me the next morning at the American Legion hut. And we'll have pancakes together. And so we said, great, this is great. And then we'll do the hike. Now, of course, he belonged to that group. We were not going to try to monopolize him. We were going to do exactly what he said. And then he put this paper sack on the table. And he said, it's going to be cold, and it was April. It's going to be cold in April along the Potomac. Here's something to keep you warm. So he left. We looked inside that sack. There was a big bottle of scotch. So we did it exactly like that story to bring it to a point. my point is, we did exactly what it was. It was cold. We drank a bottle of scotch. We had breakfast with him. And then we walked along with his wife, Kathy. Susan was there. We enjoyed that day, and he belonged then to that historic group that St. Canal. Now, I ask you, is somebody who is a total asshole like some of these professors were, would they do such a thing? No. He went out of his way to talk to the town council and make sure it would be okay for us to camp there. That's why it took him so long to come out and present this whole plan to us. So I say, yes, he was a legend. We knew that at the time. And we did everything we could to do what meet his standards. But he had a soft spot too. So I think it was great to work for. Next question.
Well, it was a blockbuster term. So one of the cases Judge Alsup assisted Justice Douglas on was Roe v. Wade, where he concurred. But I want to focus on another one, which is trees have standing too. You remember that? You've gone to law school in the last 50 years. You have read 50 years. You have read Sierra Club v. Morton. Now, that case started in this courthouse. It was a Northern District judge named William Swigert. I did not know him, but
Was it this courthouse?
in this courthouse, very courthouse. And just to remind everyone, because it may have been 50 years since you read it, Disney Corporation wanted to build a massive resort in a wilderness area, by all accounts, it's a pristine, gorgeous wilderness area called Mineral King Valley next to what's now Sequoia National Park. So to get permits from the U.S. Forest Service, the Department of Interior, Sierra Club sued to stop in this courthouse. And the big issue was in front of Judge Swigert here, did the Sierra Club have standing? And he said yes. And he granted the injunction to join the project. Went up on appeal in the Ninth Circuit, and they said no, the Sierra Club did not have standing, and they reversed. And that then went to the Supreme Court, where Judge Alsup was working with Justice Douglas, and they affirmed. Unfortunately, they affirmed, but it resulted in that beautiful, memorable dissent, one of the greatest dissents in the last 50 years of the court, from Justice Douglas, to the effect that inanimate objects in the environment should have the right in and of themselves to be parties in federal court when there are environmental issues. I'm going to read a little excerpt for you. As he wrote in the dissent, quote, "The river, for example, is the living symbol of all the life it sustains or nourishes. Fish, aquatic insects, water ouzels, that's a bird, otter, fisher, deer, elk, bear, and all the other animals, including man, who are dependent on it or who enjoy it for its sights, its sounds, and its life. The river, as plaintiff, speaks for the ecological unit of life that it is part of. The voice of the inanimate object, therefore, should not be still." What was it like, Bill? Just tell it. That's a grand opinion. What was it like to be working so closely with the justice on that?
You said it all correctly, but the majority opinion affirmed on a narrow ground and laid out the test.
Yes.
And then on remand, they were able to meet the test. The Sierra Club was able to meet the test. And that was the harbinger for all of the cases that came later, where every API, for example, American Petroleum Institute, all the industry, every single industry has, well, and that's why they have standing today, is because of this decision by the Supreme Court. But technically, it was, I guess, a dissent. And Justice Douglas came off the bench. I just happened by random draw. We split the cases by random numbers, and I happened to get the case I had done. I had read the briefs, but I had not written anything prior to it. He came off the bench, went into chambers, was in there about 2 hours, and he wrote out by longhand the text of his opinion. He then gave that to the he had 2 secretaries. He gave it to one of the secretaries. The secretary typed it up and handed it to me along with his notes. And I read that, and I said, I remember my exact thought. I said, this is going to be one of his most remembered guardian ad litem. So I said, I'm not going to change. I'm not going to do any law clerk crapola where I screw up this beautiful. So I did not. I read through it to see if there was any typos, any, fixed. If there was a typo, I would have fixed it. I don't think there even was a typo. So the text of his opinion is pristine. No law clerk. But this is an important but. If you go back and look up 403 U.S., I think it is, you will see that opinion. There's a million footnotes. Not a million, probably 30. How did they get in there? Well, this is a funny story. So he calls me in as the law clerk on the case, and he had a stack of books open to the right page, stacked up. He said, Alsup, we refer to us by our last names. I want you to write a series of footnotes based upon where I open the pages to. And basically, I want you to attack the U.S. Forest Service for their clear cutting and for their multiple, what they called in those days, multiple use. Now, I knew from having read it, it did not tie in at all. You don't ask Justice Douglas. You don't say, what, Justice Douglas? It doesn't tie in. You don't say it. I said, okay, I'll go do it. I took the stack, I put it on my desk, I worked away. I read all of them. I read, many pages before and after. And so I was able to write a coherent diatribe against the Forest Service based on these, he had it all worked out for me. But I said, where do I hang these footnotes? That doesn't relate to a single sentence. So I just decided I would tell the story 1 through 30 and put them in the right order as if you were just reading the footnotes. And then I would hang them in random. So then I left it on Justice Douglas. We would usually be there till midnight. I left it on his desk. He was usually there at 7:30. The buzzer went off. He had a buzzer system. And that meant he wanted one of us. So send in all supplies. So I go in there, and I can see he's going to chew me out because I failed him. And he looked at the opinion and he said, "This is exactly what I wanted." So look up that decision sometime. No one ever pays any attention to those things. Look it up. So that's how it got in there, and that's a true story. But the text is all 100% from the heart of William O. Douglas.
Now that preceded, you'd never been to California at that point in your life?
Oh, I had been to California briefly.
But not hiking up.
No hiking in the house here.
I've always wondered.
Now that's not quite true. My wife and I went in 1968 to Mammoth Lakes.
Mammoth Lakes, okay.
But not to Mineral King. I did go to Mineral King later.
So I have wondered then, you love the Sierras, it's been a theme of your time out here being a champion. Did it start here? Did it have any roots in this Sierra Club case?
I wondered that sometimes. I'm going to say probably not. I fell in love with the mountains in California when Susan took me on up to Mammoth Lakes, and we went backpacking in 1968. And then when I went to Beaufort, there were some people there, Bill Eldenstein, and he took me on my first mountain climb in Mount Conness. And I was sick. I was throwing up. I loved it. So I think they were, parallel, consistent, but I can't say that there was a cause and effect.
We heard a little bit about writing from Professor Lee. The one thing that really strikes me about Dissent and Morton, and even the passage I read, that clear, elegant, finely crafted language, which is plain and simple, and you get it, and it communicates everything the justice wants you to hear, but in a very graceful, eloquent way. And your opinion have those same qualities. You know, we're a writing profession. You all are writing to us. We're writing back to you. What have you thought about in terms of the craftsmanship of writing?
Well, I do think that I was influenced by his writing. And what I did, my job was to write it like he would write it, and not to, again, be the law clerk out on the mark on my own. I did learn to mimic his style. Short sentences, maybe 10 words at most. And then and also I went and read every First Amendment decision. I couldn't read everything he ever wrote, but I read every First Amendment all the way back to 1939 and made notes about it. So I needed to know his philosophy, not the majority view. I did know the majority view, but I needed to know his view. And he had been quite consistent on the First Amendment. So I learned his style of writing and did it on many, many orders. So I do think that style carried over into my days as a lawyer at Morrison and Forrester, at the Solicitor General's office, and then orders here I think he did have a clear, direct style of writing.
Let's pause on that for a moment. So at this point, you've now read, I'm sure, tens of thousands of briefs, which is grounds for medal of valor of some point at this point in your career. So people always want to know, what makes a good brief? What makes it effective just for you?
Once I went out, this was about in my 10th year on this job. On this job yet. So around 2010, I went out and I told the law clerks, this is the best brief I've received so far. And you have a 25-page limit, but this was 17 pages. And it was on a TRO. It was beautifully written. And Latham and Watkins wrote it. Anyone here from Latham? Go back and tell Latham and Watkins that I bragged about them. It was a beautifully written, concise. They didn't have multiple points. They might have 2 points, but they had whatever they said was so rock solid, it was hard to say how I can get around this. Most lawyers are afraid to give up something, so they put it in there, and then that waters down the strength of their good points. And I feel, though, that that's a mistake. Brevity is always better. One categorical sentence. My law clerks will know what I mean by categorical. Here's a good example. No decision in the history of America has ever held ABC. That's categorical. Why isn't it that you don't see that in briefs? Because the lawyers are afraid they're wrong. Because they don't get out there and do the work to be able to say. Now, a good lawyer will do the research and no, there isn't any such decision. And they will say, no decision in the history of America has ever held ABC. Well, that one categorical statement is worth pages of blather. So brevity is important, and categorical statements are important in my view. I use as many categorical statements as I could in my orders. I could give you more examples, but I'm talking too much.
Well, okay, so you spent a long time as a trial lawyer. You burnished a fine reputation for being, we used to call first-year trial lawyer in practice. I mean, exclusively at Morrison, right? You know, practice right for us. And then nomination comes and you start on the bench. And, most of our colleagues historically and today have had prior judicial experience. Some of us, me included, have come directly from practice. How did you manage, going from Friday in the office downtown to having a black robe on Monday and being asked to decide cases? That's a big transition.
Yeah, it is.
How did you make that work?
I remember the very first day. In those days, we didn't have ECF. It was still paper files. And the clerk of the court was Rich Weeking. So I had my chambers. In comes card after card after card of boxes. And they put them down on the floor. It would have been about the size of this little stage here. It was about 400 cases. And say, they said, here's your caseload. Good luck if you want it. So we went the wrong way for a few days, and then finally I said, I'm not going to read all this. It's ridiculous. I'm going to call the lawyers in every single case, and we're going to come up with a plan to ab initio for the case. And that's what I did. Did you know this? 1/3 of the case is settled right off the bat. So the other 2/3 came in. We came up with a plan for the case. I never had to read any of that stuff.
Now you tell me.
12
years later.
I do think I was shocked at how much work there is to do. And you only have, I have had a secretary, Kathy Young, she worked for me at Morrison for years and then came over. So I only had 2 law clerks. And we had a lot to do. And that was a shocker to me, how much work a U.S. district judge has got to do. You know, I bet you that brief I was talking about in Latham, they probably had 17 or 18 lawyers on the case who could contribute to it. But we're in Chambers, very small staff. And every one of those judges over there were nice enough to come tonight, thank you. They had the same problem. And yet, your U.S. District Court judges get the job done. I want you to know that. They work hard. And their law clerks are dedicated. And the magistrate judges have an amazing percentage of the cases. They work hard. And so this courthouse is a busy, busy place, as you now know.
Yeah, so how let's cut down on the filings. It's not going to kill you to have no motion to dismiss in one of your cases. So 26 years roughly in private practice, 20 plus years in private practice.
24.
You saw a lot of judges,
Yeah.
judges you admire, judges I'm sure you didn't like that much. What were 1 or 2 things that you promised yourself you would not do when you became a federal judge?
There is something. When I was a lawyer, it was very hard on me if the judge would not decide the case, the motion. And so you were sitting there, do I go take the depositions in Florida, or do I take the ones in Minnesota? Well, I don't know, because the judge hasn't told us the answer, because it could be that we're spinning our wheels in Florida. So we'll just keep waiting. So then after a while you would say, well, let's come up with an excuse to wait the judge maybe. So, by the way, Judge, here's a new decision, and maybe you should take that into account in our pending motion. And still, sometimes it would go on a year. Well, I said I would not do that. I would get the orders out quickly. It's at the district court, I think, in most, not all cases, but in most cases, the lawyers would rather have a decision, right or wrong, than have to wait and wait. So I decided I would try not to hold things up. Now, I confess a few times I was about a month after the hearing, I would get it. But most times I got it out.
You consider that late, 1 month after?
I got most of my orders out within the week of the hearing.
Okay.
I came on the bench with a prepared order.
Yeah.
And I would change it depending on how they...
Well, if the order is prepared, for
oral argument, I would know I have...
What was the purpose of the argument then? To kind
Then
of
I would test it. I would say, okay, is this a true statement or not? And I would read from my order. It was, no, that's a total lie, Judge. So tell me what's a lie. It might be a lie.
Yeah, oh, yeah, okay. Well, let me ask you one other question in the same vein. What was one thing that you promised that you get the cases out, you weren't going to be slow, but was there something else that you just thought you wanted to deliver as a district judge? This is your opportunity.
I would say, I'll say very quickly, I fell into from the following. Even though our magistrate judges like Liz LaPorte and Bernie Zimmerman were willing to take on discovery disputes,
Yes.
and I'd say most of our judges do still refer to the magistrate judges, I thought that was a mistake. Because I could get the thing decided that week. So let's say Carla Oakley writes me a letter saying, they're not producing the documents, Judge. Can we make them produce the documents? I had a little thing set up where she would send me the letter. And at first I would produce these documents. And then we go through all the excuses. Sometimes it was a good excuse. Sometimes the documents hadn't even been asked for. And they were complaining about something they hadn't even, so I'd have to, but I could get to the bottom of it in about 45 minutes. And then I'd order right there on the, I wouldn't usually do a written order, I'd just rule from the bench. Well, okay, Monday there's a problem. Wednesday it's solved. I give them a deadline to produce some documents at least. So I decided that it was better for the district judge to do the discovery. Now I confess a few times I did ask for help, so I'm not 100% clean on that. But I'd say 90% of the time I kept the cases, kept the discovery. Here's another thing, the lawyers don't want the district judge who's going to try the case or grant or deny summary judgment. They don't want them to know how they have misbehaved. So they act better. They're a little bit better than they are if it's going to go to the magistrate judge who's not going to try the case or rule on summary judgment. So those are speed, keeping it going, and just the interim effect of having to appear before the district judge and be exposed for the fraud that you are.
You're not from this district, you're doing your little discovery thing, and then you stumble into this. You realize you're not coming back. That's why.
I'm not coming back. You're safe now.
Yeah. Well, now, I mean, you have had a legendary number of famous cases. Many of which have gotten not only precedential value but tremendous amounts of press coverage. But I'm wondering, Bill, what's maybe one case or two cases that didn't get that kind of press coverage, flew under the radar, that really meant something to you?
Yeah, I'm going to give you one example that, thank you for asking me that. I'm going to give you one example that, there are hundreds I could give you. Hundreds, a handful of hundreds of cases where you feel very good about what you did that day. It was a criminal case. I can't remember the lawyer anyway. It was early on. I'm going to say 2002 or 3, something like that. And it was a drug case. The guy had been convicted of a lot of, kilo-sized, serious drugs, not marijuana. So we came to the sentencing, and he got a sentence. I think in those days it was mandatory for the guidelines, but he got a low end of the guideline range. It was still a lot. It was many years in prison. So then the lawyer asked for something special, and the defense lawyer, and there was no one in the courtroom, just me and the prosecutor and the defense lawyer and the defendant. And but then there was this elderly man in the back, and he said, I want you to let him out, the defendant out, so he can help his dad move from his home to assisted living. And because he's going to be going away for a long time, he'll probably die while he's in prison. And the elderly man in the back was his dad. And he happened to say to the lawyer, by the way, there's a statute on point. I don't think I could really do that. But it had some exception, but probably did not really apply. But I said, well, tell me about it. Tell me. So he said, well, the dad was a pilot, the Tuskegee Airmen. And many of you know who the Tuskegee Airmen were in World War II. Tuskegee Institute in Alabama, it was all segregated, and had pilots. The Army trained, Air Corps trained them. They turned out to be a heroic group in Europe, in the European theater, protecting the bombers. Really heroic. So there's been movies about them. The Red Tails movie is an example. Anyway, but this is back in 2002. That movie hadn't come out yet. I knew all about the Tuskegee Airmen from having read some history. And so I was impressed. So I asked the man to come forward, and he said, yeah, that's true. I was Tuskegee Airman. So I said to the government lawyer, I said, why can't we do this? And he said, no, not going to flee. I said to the lawyer, this is sometimes whenever, if you have some credibility, it comes through and pays off. So I said to the lawyer, is your guy going to flee? He said, no, he promises he'll be here. I said, you promise? Yes. So I then said, this man, referring to the airman, did something good for his country. And now his country is going to do something good for him. So I let him out. And it went fine. He didn't flee. He got his dad into the assisted living. And then he reported for duty to the prison. So I felt pretty good about that. Now, did I follow the statute? Probably not. Probably not. And I want you to know that was against my normal principles of you got to follow the law. But this was a case of the extreme equities.
Well, you follow the law, you just exercise judgment.
Well, the statute said you were supposed to do it.
I get it.
All right. Anyway, I felt good about it. I worried that something I did. I felt he would. I actually believed him. I thought he would. I believed the lawyer, and I believed the defendant and his dad. It cried out for some equity.
That's the judgment part.
Yeah.
But you were a trial lawyer, you're a trial judge, we're in a trial courthouse. Everyone knows federal jury trials now are less than 1% of all civil cases, slightly higher, only slightly higher for criminal cases. And that's a market decision. Lawyers and clients have decided they don't want jury trials. And people say, oh, it's arbitration. Well, people said we want arbitration. I know sometimes it's forced down people's throat, but bench trials on. And this year and the last year, in my experience, I know from some of my colleagues, the number of parties jointly requesting bench trials because they don't want to go to a jury has skyrocketed. And they create special problems. But given how close and how important jury trials have been throughout your career, on and off the bench, what are people losing? What are these litigants and what are these lawyers losing by electing not to go to jury trials?
I do believe in the jury system. I think it's a great system. And I think in my experience that juries were very close to the correct in every case. And I really, even where I thought maybe they were a little off, not by much. So I think it's a good system. It does require good lawyers on both sides. And importantly, a judge who knows how to run a trial, a fair trial, an efficient trial, and does not send the jury out into the hallway for hours on end while the lawyers drone on about some motion to eliminate. You don't do that to the jury. The lawyers cannot, at least I wouldn't let them do that. We moved it along, the juries appreciated it, and so if you have a reasonable judge and two good lawyers, I think they usually reach the right decision. However, that's not really the reason for someone who's afraid of a jury trial to go to. What we lose, the system loses. One of the people who come in to serve on the jury, uniformly, all my colleagues would back me up on this, they write letters saying, this is the fairest thing I've ever seen. I did not want to serve, but now that I've done it, this is a wonderful system. So the institution loses when we don't have jury trials because the public, by serving, has confidence in our system. Now, can I just give me 1 minute more? Here is a great paradox. This has been true since World War II. The federal courts are the most respected branch of government by far than any other branch of government. Congress is down there with the HMOs. The president, over time, both parties, usually somewhere in between, but nowhere near where the federal courts are. And yet, no one in the federal courts are elected. It is about as anti-democratic as you can get. We are not elected, we serve for life. And yet, the public has more trust in us. How could that be? It's paradox. Well, the reason, I think, is because we're the one branch of government that decides things on the merits. Could you go to Congress and plead your case? fair hearing, and their case will be decided on the merits. And the public respects that. And the jurors see that when they come in. So I think what we lose is the institution loses whenever we don't have that group of Americans coming in to serve on the jury.
So just to follow, so we live in a famously divided time where everybody is polarized and unable to agree and looks for conspiracy explanations and doesn't look at the evidence and comes in with preconceptions. These are all the views of our fellow citizens today. So how is a jury going to work in your view in that kind of a context where people are polarized, maybe not evidence-based?
I think when they come in and they become friends in the jury box, they overlook those. They don't want to talk politics in the jury room. I don't think they do. I think they go in the jury room and they're like a community of people. We've got a job to do. This is me talking now. I think they go in there and say, did you see how hard that Judge Donato is working? Did you see how hard he's working up there? He's doing his job. We got to do our job. We got to come to a verdict. I think that's what they're saying. They're not talking Democrat or Republican. No. So I don't think that argument pervades into the jury.
But that was a devil's advocate point. I could not agree more, and I'll tell you the one thing, no matter, our jury pool goes all the way from the Oregon border down to Monterey County and then, inland. So it's a very diverse pool. The one thing that all jurors have done, in my experience, as recently as last month when I tried 2 cases, when you have a common set of evidence governed by a common set of rules, people make the right decision, regardless of what they come in with. So if you're worried about polarization and you think that's a reason not to go to trial, don't let that be a problem, because I think that's actually the antidote for a lot of the polarization that we have. We're in this lovely courtroom. It's named after Thelton Henderson. I think you were nominated to take his seat when he went senior. He's been a tremendously close friend, a dear friend of yours for many, many years. I'm wondering, what did Judge Henderson and Thelton do for you in terms of kind of fashioning your approach to the bench?
I'm going to tell you what the answer is, but I failed in some respects, Judge. And I appeared in front of him as a lawyer. And he was so courteous to the lawyers, even when they did not deserve it. He was so courteous to the lawyers, and he was able to hold his temper. He might actually be upset, but he would be eternally patient on the bench. And when I started out, I think I was meaner to the lawyers than I should have been occasionally. But as I went on, I would say, I should be more like Belton. And I tried, and I think I mellowed some, but I never got all the way to
Full Henderson-ness.
I did not get that.
Yeah, I mean, it's a challenge for everyone.
There are many other great things I could say about Belton, but that is definitely one that I try to remind myself that example many times.
So in the time going back to Justice Douglas for a moment, so everyone who has gone to law school recently, meaning the last 5 decades or so, we're all textualists. It's been all beaten into us. Okay, you look at the plain ordinary meaning of the statute, you don't read anything into it. Justice Douglas was a little bit different. He saw penumbras, emanations, and the Bill of Rights, for example, for the rights of privacy. Wonderful results. Results I think most people would embrace. Yeah, you should have a right of privacy. But sort of the method of getting there is now completely at odds with what we are taught to do, both as law students, lawyers, and as judges. So how did you handle that in your own judicial career? I mean, you're not an emanations penumbra person, but you trained with someone who really staked a lot on that.
Well, the Supreme Court justice is, completely different animal than a district judge. We have to follow not only the Supreme Court and the statutes and the precedents that apply in the Court of Appeals. So I felt pretty strongly that we should stick to that. I gave you an example just a minute ago where I didn't stick to the statute. So I wasn't always true to that, but generally I was true to it. I do think the words should count, especially in statutes. The words should count, and they ought to be the first thing we look at. But many times in chambers, I would say, give me the legislative histories. There's the library here. I would call up Susan Calder and say, I got an important ADA case here. I want to know the whole legislative history. Now, the legislative history thing is out of favor with some of the justices now, but that was the way I was taught in law school. I wanted to see what was the problem they were trying to solve, and did they see any other problems? And so I wanted to see the legislative history. I wanted to see all of how it had been construed, how well it had been briefed in all those other cases. This is whenever it was important. I knew it was going to go up on appeal. I did do that in every case. Maybe 1 out of 40 cases, I might give it that kind of scorched earth treatment. Sort of come back to your question, yeah, the words count, the text counts. That ought to be the first thing you look at. But I don't think it's the only thing you should. I'm still in the old school. I can't get rid of it. I think you look at legislative history, you look at the Federalist Papers, you look at what were the things going on at the time that they adopted the statute, and then do your best to see what the congressional intent was, or the framers' intent. But I also do think this. I think you can't say, like take guns. No, the framers never knew about assault weapons, rifles. They had muskets, smoothbore muskets. They never dreamed of magazines that held 30 rounds. So to say what did the framers think about the problem is really naive in my view. I think you have to have a bit of a living document because it changes. The circumstances develop over time. Less so with statutes because those can be fixed up, but with a constitution, I think you need to have more of a living document. Stephen Breyer wrote a book when he went off the court, which says it much better than I'm saying it right now.
I'm going to ask an advocacy question, and then we're going to close with a question about Mississippi. You have seen thousands of lawyers in the courtroom.
Yeah, what?
You've seen thousands of lawyers in the
Yes.
courtroom. You know from your own experience what's good, what's ineffective in making an argument. If you had to boil your advice down to maybe just 2 points, what makes for a killer oral argument in front of Judge Alsup?
Come prepared with a categorical statement. And the second thing is, I learned this in practice. Maybe I taught this to Harlan. You pick out the 10 most important documents that are short, not long ones, and hope that the judge gets interested in it. And then, whenever the other side starts to quibble over what it actually said, which they always do, you say, Judge, here it is, right here. And you hand it up like this, and it's highlighted in yellow. And it says exactly what you said. Have the 10 most important documents at the ready. Most times you'll never get a chance to use a single one. But sometimes you will. And it's a killer diller whenever you can hand that document up to the judge.
I'm sure you've all heard Bill's book, One Over. It's a first-person account growing up in Jim Crow South and the awakenings that Judge Alsup had during the Civil Rights trial. In 1963, Medgar Evers was killed in Jackson, Mississippi, and his son Medgar Evers was one of the great civil rights leaders at the time. And his house became a National Park Service national monument hosted by the federal government. A couple months ago, early part of this year, the National Park Service redid out any description of Everett's assassin as a racist. This guy was a member of something called the White Citizens Council and the KKK. Deleted all that, so you had none of that information about Everett's assassin, and took out the horrible death. I think he got shot in his driveway. He struggled for 30 feet to get into his house. It was a slow, agonizing, cruel death. Deleted all of that.
In front of his wife and children.
In front of his wife and children. Deleted all of that. And I'm just wondering, given your history, and by the way, that was all done officially, according to the Park Service, to restore truth, is I think the phrase that government used, to American history. No, it was restore truth and sanity to American history.
Well,
you must have some thoughts.
I do have some thoughts on that, and it will take me a minute or two. I'm going to start with the positive one, which is that I think some of our great leaders have said that America is the last great hope for civilization, and that we're the country that should stand for the right thing, and we have the strength to back it up. The world may come to depend on us like it did in World War II. America stood up at the right time when it was needed. But we have a lot of sins to account for too, don't we? Slavery being the worst sin that our country committed, but others, I could list a few, but I don't need to do it right now. But what is important is that in that process of, as Martin Luther King said, the arc of justice bends, the arc of history bends towards justice. You don't get there unless you acknowledge the things you've done wrong. And I think the Catholics have a term for expiation, that is where you call out from within yourself the things that your sins, the sins you've committed, so that you can then atone for your sins. You have to acknowledge that you did it wrong. You can't erase your sin, and so the expiation. Well, I think that's the way we have progressed in our country, is that we come to recognize our sins and seek atonement by doing better. And we're slowly getting there. Now, to come back to this thing with this terrible move that the National Park Service was going to say, take out the word racist, and say that the guy who killed Ben Rivers was they were just going to take out the word racist. Well, that guy was at the time proud of being a racist. He bragged about it later on, whenever after the acquittal in that, or the hung jury, not acquittal. So he definitely was a racist, and many of us lived through that period, and it was one of our sins that followed slavery was racism, and it's still with us today. And if we don't acknowledge it, and we're never going to atone for it, we're never going to fix it. So we have to make that step. So I was upset whenever I read that the Park Service was going to, candy coat the description at Rivers Home. And I hope that they change their mind and go back to the original description. That guy, the assassin, was a racist through and through, bark to court. So we should be willing to admit that, acknowledge that, and say that we're now a better country.
Okay, I think that's a great place for us to stop. We're going to have an opportunity to talk more and visit with Judge Alsup at the reception. Thank you.
I thought you were going to ask some questions.
Well, questions have been solicited.
If somebody, let's take one or two.
Are there any? Does anyone? There must be. Yes. You got to boom it out. So, yeah.
Judge, what are you going to miss most about this job, and what are you happiest to never have to do?
Please repeat the question for the video.
Yes. The question was, what am I going to miss the most?
And what are you happy?
And what am I not going to miss the most?
Yeah.
The answer is I enjoy being on the bench. And I like trials. I like running a trial, even though it's stressful. I like doing it. And I like oral arguments with the lawyers. I like the give and take with the lawyers, like Ethan Ballo back there. He and I would go at it, and he would tell me this and that. And I like to get the interchange with the lawyers. Here's a little pointer for some of you. Many judges prefer to read the briefs. And they like reading. And they're good readers. I am not a good reader. I'm a slow reader. I learn much quicker and faster by hearing, listening. So I like to listen to the lawyers, and I would then ask questions, and I would get to the bottom of it much quicker than I would by reading the briefs. So I'm going to miss that give and take. Even though I did the discovery disputes, most of them, I am not one of them.
Other questions?
Is there one more question?
One more. Yes, please.
Judge Alsup, Nancy Shimano. One Over is one of my favorite books. Tell everybody about the billboard. And what it taught you.
Oh, billboard, that's chapter 1 of that book. It's too long a story, but at that time there were impeach Earl Warren billboards all over the South, and actually in the North too. And they said impeach Earl Warren, because this was put out by the John Birch Society. So me and my friend Ron got upset over it because one of them went out outside of Jackson. And we decided that we were going to paint over it. It's a full-size billboard. And we had some spare paint in my garage, so we mixed it all up into this beige color. And then I called up the young woman that I was sweet on. And she wasn't as sweet on me as I was on her. Just before I knew my wife. And so she, I said, guess what? She said, well, what are you up to? And I explained what we were going to do. And then I realized, and then she said, can I go? Because she wanted to be in on it too. So now I was stuck. I couldn't back up. So we did go out and we painted over the billboard. We had to climb up the rafters on the back. I told Ann I made her stay in the car, but she was still a co-conspirator, I later learned, and was just as guilty. Anyway, we got out just in time. The highway patrol were converging on the scene, and we got out just in time. They never did catch us. Later, when I did my book, I went to an event in Jackson, and one of my classmates came up to me. She was, I forgot her name. She said, you know, my dad is the one that put that sign up. And I'm so glad you painted over it.
All right, so let me thank, before we hear a little bit more from Randy Supalek, she did an enormous amount of work to put this together, as did the Federal Bar Association.
Remarks are intended for you. I met you 15 years ago, following a 5-month jury trial in your courtroom, and since then we've become very close friends. Over the years, you've been a staunch supporter of attorneys and the Federal Bar Association. And the huge turnout we have tonight, many more people registered to come, is a testament to the respect that attorneys have for you. In the attorney conference rooms your photographs grace the walls of San Jose and Oakland and San Francisco divisions. But here in San Francisco, there's a small framed note that you wrote that reads as follows. These photographs are dedicated to trial lawyers and their important work. They have the hardest job in the courthouse. I don't know if many people have seen that, but you have always been willing to speak at federal bar programs on common pitfalls that attorneys make, on the proper use of rules of evidence, and what effective cross-examination is. Based on your respect for trial lawyers, the Federal Bar Association's Northern District of California chapter is going to have a William Alsup program on trial advocacy. This will be an annual event that I hope you will attend and perhaps give me some suggestions on what we can talk about. But it is in your honor. I also have a couple of gifts for you. One, I think you can tell by the wrapping.
Justice Douglas all over again.
It's a very good bottle of scotch that you can enjoy with Susan tomorrow night or later this evening. And then there's a picture that I know that I have developed for you that I think you will cherish of you and Kathy. So we're going to conclude now. There is a reception where I hope everyone attends and gets a glass of wine to toast the judge.